Mililani Trask.
Aloha board members. I'm Mililani Trask. I'm a native Hawaiian practitioner of Mauna Kea. I'm a founding member of Mauna Kea and Idaho, the original petitioners who will go to the Supreme Court in August. 18 years ago, Mauna Kea and Idaho and the Royal Order built the ku'ahu at the Halipuhaku. We maintained it for many years. I practiced there for 4 years till problems with the science community and tourists caused me to change my practice. In 11 and 12, we planned the Apapalani ceremonies. We held them 3 consecutive years, and my family and myself were there. The Apapalani ceremonies are sunrise ceremonies at Mauna Kea, and that occurred 2013, 14, and 15. In recent months, I have returned to my practice on the Mauna. I camp out. I have a sleeping bag. If it's 40 degrees or below, I sleep in the car. If it's 40 degrees and above, I sleep on the cot in the tent. I was up there about a week and a half ago. Trustee Hulu Lindsay and other trustees were sleeping in their cars next to mine. I'm there not because I'm a hunter or a camper. I'm there because I'm exercising rights in Article 12, Section 7 of the state constitution. Our rights are not limited there. There are 2 exceptions in our state law that I believe you would have to take a look at and include if you're looking to adopt any language here. The first exception is Chapter 171-6, subsection 15. It provides that in exercising the powers for regulation of state land, no person could be sanctioned who says that they are there for the purpose of utilizing or exercising rights in Article 12, Section 7. This is in the current statutory framework now. 171-6, subsection 15, paragraph 3. No person shall be sanctioned pursuant to this section for the exercise of Native Hawaiian gathering rights and traditional cultural practices as authorized by law or permitted by the department. I have gone to the OMKM and also DLNR to request if there is some permit, if there is some license that my family and I and the other kumus who did a papalani could obtain so that we could do 24/7 practice. The answer was there is no permit available for us. There is no permit available. Now the second exception to our right arose when the legislature passed Act 132 in 2009.
15 seconds, so if you could
that was the University Autonomy Bill. If you take a look at Act 132, it has very clear language that the university shall accommodate Native practice, but they have refused to do so.
You could
Lastly, there's a federal district court case on point here. It's a case that came down years ago when the Protect Kaho'olawe Ohana was trying to get overnight access on Kaho'olawe. The case was in the district court. The military said that they had a long-term lease, there were live ordinances, and they were doing training and bombing exercises. The federal court struck them down, and the federal court required that they provide 24/7 access for Native peoples 7 to 10 days a month by the cycle of the full moon with full military escort. You know, that's a precedent we should look at. I think that we could work together if we could have a consultation of the Native practitioners, which has never occurred. Once we have the consultation, we can understand the practice, the location, the nature of the practice for those that are doing sunrise or sunset. But we can't make a cultural resource management plan without first having the consultation and the data. And I have done this all over the world with my work at the UN. You think you have a problem? In the Philippines, we had 50,000 demonstrating, 3 killed over the World Bank, and we were able to resolve it. These are rights to worship. I can't be a camper. I don't want to be a hunter. I will be returning with my sleeping bag. I will not be told for 120 days that I cannot pray to the Akua. And I'm requesting that you put the exceptions in that the law currently provides for me, so that I do not have to have my constitutional and human rights violated. Thank you.
Thank you.